Welcome, ya marhaba, ya ahlan wa sahlan. Welcome to the Rutgers Law School Center for Security, Race, and Rights Free Speech and Racial Equality Lecture Series. This is our third lecture in the 2025 to 2026 lecture series, and this is our first one for the spring of 2026. We are so honored to be featuring Professor David Rabban to be presenting on academic freedom from professional norm to First Amendment right, which is based on his book by the same name. Before I introduce our distinguished guest, I want to tell you more about the Rutgers Law School Center for Security, Race, and Rights. It is the first and only academic center at an American law school that focuses on the civil and human rights impacting Muslim, Arab, and South Asian communities. We do so through a cross-racial and interdisciplinary and an interfaith approach. If you haven't already subscribed to our social media, please do at Rutgers CSRR and at RU CSRR. Make sure you go to our website at csrr.rutgers.edu and take advantage of the numerous resources that we have about these diverse communities, including trailblazing policy reports, issue briefs, and op-eds and media interviews by our over 180 faculty affiliates of diverse backgrounds and disciplines. And if you are a podcast listener, please make sure that you subscribe and rate the Race and Rights podcast. Our latest episode was just released 2 days ago, and it features Professor Atiba Ellis talking about redistricting, race, and democracy. And finally, if you find the work of the Center for Security, Race, and Rights informative, helpful, important, please consider making a donation to CSRR. Go to csrr.rutgers.edu, press the donate button, and please give generously. We rely on our supporters for our funding. So, as we say, vote with your pocketbook in this case. Now, it is my distinct pleasure to introduce today our guest lecturer, our guest speaker, Professor David Rabban. He served as counsel to the American Association of University Professors for several years before joining the University of Texas faculty in 1983. And a special personal note, Professor Rabban was also a professor when I was a law student, and certainly one that we all admired and continue to admire as an internationally known scholar on the First Amendment and its various dimensions. Professor Rabban served as general counsel of the AAUP from 1998 to 2006 and chair of its Committee on Academic Freedom and Tenure from 2006 to 2012. His teaching and research focus on free speech, higher education and the law, and American legal history. He is the author of Free Speech in Its Forgotten Years, 1870 to 1920, which was published by Cambridge Press, and also received the Forkosh Prize from the Journal of the History of Ideas for the best book in intellectual history, published in 1997. His many academic articles have appeared in the Yale Law Journal, Stanford Law Review, University of Chicago Law Review, Cambridge Law Journal, and elsewhere. He was a fellow of the John Simon Guggenheim Foundation in 2016 and of the program in Law and Public Affairs at Princeton University. And his most recent book, which again we are so honored to be featuring today in our lecture series, is entitled Academic Freedom, From Professional Norm to First Amendment Right, which was published by Harvard University Press in 2024. Professor Rabban, thank you so much for being so generous with your time and your expertise and coming to educate the diverse audience and attorneys that we have here today listening. And again, it is such a special treat for me as a UT Law graduate to be hosting you today. So the virtual floor is yours, Professor Rabban.
Well, thank you very much. I really appreciate this invitation, and thanks all of you for joining on Zoom. And it is kind of neat, isn't it, to have a former student at the University of Texas being the host of this series. So what I want to do in my presentation is first present some background on the meaning of academic freedom as a First Amendment right and as a professional norm, and then to focus on recent threats to academic freedom from state legislatures and from the Trump administration. So very briefly, I'll start with academic freedom as a professional norm, which dates from the founding document of the American Association of University Professors, where, as you've heard, I used to work and have been associated with throughout my career. The 1915 Declaration on Academic Freedom and Tenure remains the most important justification for academic freedom as a professional norm. And it is the foundation for many current university regulations dealing with academic freedom. And the core point of the 1915 Declaration and its justification for academic freedom is that professors cannot do the job they are hired to perform, namely to produce and disseminate knowledge in the public interest, if they can be fired for reaching academic conclusions that offend others. Therefore, the protection of academic freedom is needed for that academic expression. The 1915 Declaration also pointed out that academic freedom only applies to speech that meets academic standards. It emphasized that only professors have the competence to determine whether academic standards are met. And therefore, in the 1915 Declaration, peer review became an important element of the system of academic freedom. So there's a very brief, but I hope helpful, summary of academic freedom as a professional norm. And now I want to get into the complicated issue of academic freedom as a First Amendment right. The Supreme Court initially recognized academic freedom as a First Amendment right in a case called Sweezy versus New Hampshire, which was decided in 1957. And I think it's useful to give a little bit of background on the Sweezy case, which was decided at the height of the Cold War. Okay. New Hampshire had a law that prohibited the state, including state universities, from employing quote unquote subversive persons. And the legislature asked the state attorney general to investigate whether any subversive persons were currently employed by the state of New Hampshire. Okay. As part of his investigation, the Attorney General of New Hampshire subpoenaed a Marxist economist named Paul Sweezy. The Attorney General asked Sweezy all kinds of questions, which Sweezy answered, but Sweezy refused to answer questions in two categories. One category had to do with the political activities of his wife in the Progressive Party. And the other set of questions had to do with a visiting lecture that Sweezy had recently given at the University of New Hampshire, a state institution. For example, the state attorney general asked Sweezy, "Is it true that in your guest lecture you advocated Marxism, that you advocated the theory of dialectical materialism?" And Sweezy refused to answer based on his First Amendment rights. The New Hampshire courts rejected Sweezy's First Amendment arguments, but the Supreme Court accepted them, okay? And the Supreme Court reversed the contempt conviction of Sweezy for refusing to answer those questions. Chief Justice Warren wrote an opinion for a four-person plurality of the Supreme Court, saying that the questions from the state attorney general that Sweezy refused to answer unquestionably violated Sweezy's First Amendment rights in the areas of academic freedom and political expression. And I think it's obvious that these two separate categories of First Amendment rights, academic freedom, for the first time recognized, and political expression, grew out of the nature of the questions that Sweezy refused to answer. Justice Frankfurter, who had been a law professor before his appointment to the court, wrote a concurring opinion in Sweezy, signed by Justice Harlan. So the floor, and that concurring opinion also recognized academic freedom as a First Amendment right. So the 4 from the plurality plus the 2 from the concurrence made 6 justices who recognized academic freedom as a First Amendment right for the first time in Sweezy. And in Frankfurter's very influential concurring opinion, he repeatedly emphasized the importance of preventing government intrusion into the intellectual life of universities. In support of that position, he quoted from a recent South African statement on academic freedom. And that statement, quoted by Frankfurter, has repeatedly been reiterated since the Sweezy case itself. And I want to quote from part of what Frankfurter himself quoted in that concurrence. The South African statement referred to, quote, the 4 essential freedoms of a university to determine for itself on academic grounds who may teach, what shall be taught, how it shall be taught, and who may be admitted to study. A decade after the Sweezy case, in a case called Kiishian versus Board of Regents in 1967, a Supreme Court majority identified academic freedom as a quote unquote special concern of the First Amendment. Okay, so there's the basic establishment of academic freedom as a First Amendment right. But very frustratingly, since the Kiishian case in 1967, while its comment that academic freedom is a quote unquote special concern of the First Amendment has been repeatedly quoted or cited, the cases have not indicated how academic freedom is special, nor have they indicated the relationship between the First Amendment right of academic freedom and general First Amendment rights of free speech. So this is very frustrating. But from the hundreds of decisions that have discussed academic freedom as a First Amendment right, a basic consensus emerges about its scope. Judges disagree about all kinds of issues related to academic freedom as a First Amendment right, but there is a consensus that academic freedom protects the content of academic speech in teaching and scholarship. That's the core concept of academic freedom as a First Amendment right. Now, I want to mention 2 complicating factors in understanding the meaning of academic freedom as a First Amendment right. The first is that legal decisions often don't even mention academic freedom when it clearly applies to the facts of the case. And I want to give you one example of this. States passed laws prohibiting the teaching of evolution or requiring the teaching of quote unquote creation science. This legislation obviously raises academic freedom issues. Professors who challenged this legislation raised academic freedom issues, and sometimes the lower courts addressed them. But the Supreme Court, in declaring the legislation unconstitutional, did not rely on academic freedom, but instead claimed that this legislation constituted an unconstitutional establishment of religion. So it avoided the academic freedom issues. And there are many other cases that avoid academic freedom issues that are clearly presented. So while academic freedom has clearly been recognized as a First Amendment right, it's also been clearly ignored, which casts doubt, I think, on how broadly established academic freedom actually is as a First Amendment right. Okay, a second complication. Many courts have applied general First Amendment law related to free speech in ways that have denied claims that would have been protected had the courts applied the distinctive First Amendment right of academic freedom. And I want to give two examples coming from the law dealing with speech by public employees, sometimes called employee speech jurisprudence. In order to be protected by the First Amendment, speech by a public employee must be about a matter of quote unquote public concern. If the speech is about a matter of private concern, it's not protected by the First Amendment. Many courts have held that academic speech by professors is about a matter of private concern, not protected by the First Amendment. For example, abstract theorizing, private concern. Criticism of administrators designed to make the university better, private concern. A claim that a professor was denied tenure in violation of her academic freedom, a private concern within the university, not a public concern, not protected by the First Amendment. But these issues are obviously raise matters of academic freedom. Some courts find that the First Amendment right of academic freedom applies to this kinds of speech, but many courts do not. Finally, and worst of all, in my opinion, in 2006, the Supreme Court held that speech by public employees, quote unquote, pursuant to their official duties, are not protected by the First Amendment. I was general counsel of the AUP when the Supreme Court granted cert in this case. I saw the grant of cert and I said to myself, what are the official duties of professors? At the core, they're teaching and scholarship, precisely what's been protected by the First Amendment right of academic freedom. So the AUP wrote a brief in this case, but the majority upheld this notion of speech by public employees pursuant to their official duties are not protected by the First Amendment. But the majority added at the end of its opinion, I like to think because of the AUP brief, the majority said, there's been some concern that applying this test to professors might affect their ability to teach and write scholarship protected by the First Amendment. But this case does not involve a professor. It involves a district attorney, and therefore we do not have to decide this issue. So my reaction was that was a close call. But in the 20 years since this decision, some lower courts have actually found what they've called a First Amendment academic freedom exception to the pursuant to official duties test. But other courts have applied this test to the expression of professors. So the reaction is mixed. It's a real problem. Okay, these and other problems with the current interpretation of academic freedom as a First Amendment right lead me to propose, and I developed this in my book, a distinctive theory of First Amendment academic freedom, different from the general First Amendment right of free speech. To be convincing as a distinctive theory, I think First Amendment academic freedom must both be differentiated from the general First Amendment right of free speech, but still must explain why it fits within the First Amendment. And in my view, the societal value of the expert academic speech of professors both differentiates academic freedom from free speech and connects academic freedom to the widely recognized First Amendment interest in the production and dissemination of knowledge. Professors cannot perform their function of producing and disseminating knowledge if they are subject to discipline for reaching scholarly conclusions that offend others. The same justification for academic freedom as a professional norm in the 1915 Declaration, in my opinion, also justifies its distinctive treatment as a First Amendment right, different from general First Amendment rights of free speech, but still encompassed within the First Amendment. In my view, this First Amendment right should extend beyond the specialized knowledge of professors within their disciplines. It should extend also to questions of educational policy. But, and this is controversial, in my view, the First Amendment right of academic freedom does not, should not extend to speech by professors unrelated to their expertise. It's expertise that justifies that distinctive right. So under this analysis, I want to point out this distinctive First Amendment right of academic freedom provides more protection to the expert academic expression of professors when it meets standards of peer review than the general First Amendment right of free speech provides to the expression of others, including other public employees. But if the professional speech of professors does not meet academic standards as determined by peer review, professors may be disciplined even if similar speech by others would be protected by the general First Amendment right of free speech. I also want to emphasize, though, that if professors speak outside their expertise, the First Amendment right of academic freedom does not apply. It only applies to the expert speech of professors. When professors speak outside their expertise about politics, for example, they should be subject to the same First Amendment principles that apply to all public employees or citizens. So I want to point out that the First Amendment right of academic freedom, originally recognized for professors, has been extended since the 1970s to universities as institutions. First Amendment academic freedom now applies to institutional academic freedom as well as to the academic freedom of professors. And in recognizing institutional academic freedom, decisions also often refer to the four aspects of academic freedom in the South African statement cited by Frankfurter: who may teach, what shall be taught, how it shall be taught, and who may be admitted to study. So I want to close now by discussing recent legislation in some states and demands on universities from the Trump administration in 2025 that have challenged the prevailing judicial interpretation of the First Amendment right of academic freedom since the Supreme recognized it. in 1957. Did that come through? Okay. So, legislation in some states, as you probably know, have prohibited teaching quote unquote divisive concepts, often related to issues of race and sex. Demands from the Trump administration have conditioned federal funding of academics research on requirements that universities place academic departments in receivership, that universities create new programs, hire new faculty with viewpoints acceptable to the government, base admission of students on purely quote-unquote objective criteria, restrict the percentage of foreign students, and close diversity, equity, and inclusion programs. And the main point I want to emphasize is that these restrictions involve substantially more government intrusion into the intellectual life of universities than the Supreme Court invalidated in the Sweezy case. Remember, in Sweezy, the questions from the state attorney general only asked about the content of a lecture. The recent legislation and demands from the Trump administration, by contrast, prohibit professors from expressing scholarly viewpoints disfavored by the government and regulate university educational decisions about curriculum, faculty appointments, and student admissions. And this kind of government intrusion in university affairs is unprecedented. Now, as you know, some universities have acquiesced to these restrictions, but litigation at 4 universities have challenged these restrictions on First Amendment grounds. 3 of the decisions in federal district courts, consistent with the overwhelming consensus of existing law, found that the government violated the First Amendment. Okay. The 4th decision rejected the First Amendment challenge to an Alabama law while recognizing precedents in most jurisdictions did not support this result. So, to conclude with a question, will the courts, particularly the Supreme Court of the United States, continue to follow the existing judicial consensus? The same judge who concluded that the Trump administration's demands on Harvard University violate the First Amendment had previously upheld Harvard's use of affirmative action in student admissions. But in 2023, as most of you probably know, departing from precedents since 1978, the Supreme Court reversed her decision and held the Harvard affirmative action plan unconstitutional. Will the Supreme Court similarly depart from precedent and reverse her reasoning in the more recent First Amendment case at Harvard? I think that some of the justices who voted against Harvard in the affirmative action case would support its First Amendment claims. Yet it's very hard to predict, I think, what the Supreme Court will do, especially when the Supreme Court is reversing so much prior law on so many subjects. At my most optimistic, and I'll end with a note of optimism, I hope that future decisions arising from current litigation will both clarify the meaning of academic freedom as a First Amendment right while continuing to protect it. So thanks for your questions. Thanks for your attention. I look forward to your questions and comments, including from Sahar.
Thank you so much, David. That was a very succinct and coherent summary of what I highly recommend, the book, Academic Freedom from Professional Norm to First Amendment Right. I recommend that folks purchase it. If they haven't already, you can go to Harvard Press and get a 20% discount by using the code ACA20, and we'll also put that in the chat. So while we wait for questions from our audience, I'd like to use kind of my moderator's prerogative to ask you a few questions I had as I was reading the book. I have more questions than we have time to ask, but one that is particularly on my mind is the issue of extramural speech, especially in light of social media. And as you know, for the last 2 years, and we're still going, and it was for different reasons. I mean, I'll tell you from the vantage point of the work that I do on Muslims and Arabs and South Asians and Palestinians, there was a concerted attack against faculty whose extramural speech, and in some cases also, usually was related to their research and their teaching, connected to Palestine, and specifically critical of the state of Israel and their policies and practices in Gaza. You know, there were faculty who argued that based on their expertise, it was a genocide that was happening. There were faculty who were supporting and advocating for the elimination or at least pause of U.S. Funding to the military of Israel. So much of their speech was on social media or sometimes quoted in news media, or they were writing op-eds. Where does your theory fit, or how does your theory apply to this extramural speech, especially when it is by faculty, right? So it is not just a private or a non-faculty citizen who writes an op-ed or who writes on social media, but this is a faculty member and they are posting on their social media, and then they're experiencing attacks from politicians, from students, from special interest groups, demanding that they be fired or disciplined, or their employment be adversely impacted in some way.
So I think the first important issue is whether faculty are speaking within their expertise or whether they are speaking outside of it, but based on kind of general concerns about these issues. As I tried to indicate in my comments, like for purposes of First Amendment academic freedom, right? The First Amendment right of academic freedom applies to expert speech by trained professors. And to the extent that professors are speaking about the Gaza war, issues involving Israel, Palestine, to the extent that they are speaking within their expertise, they should be protected by academic freedom. And their claims, right, if there's a claim that their speech is unprofessional, doesn't meet academic standards, that speech should be resolved by fellow experts, not by administrators, not by politicians. So expert speech should be covered by, protected by academic freedom, though, right, if alleged expertise does not meet the standards of the field as defined by other academics in that field, it's not protected. To the extent, and I do think there are a lot of people who are not specialists in the Middle East who are commenting on what's going on there. Many professors are doing that. That is not speech that falls within academic freedom. It's speech that falls within the general First Amendment rights of free speech. So when you're speaking within the First Amendment right of academic freedom, you have more protection based on academic freedom, but to a certain extent, you may have less if your speech does not meet professional standards as determined by faculty peers. A non-expert can say something really stupid and even wrong about the situation in the Middle East. It's protected by general free speech. If a professor who's not an expert says something wrong about it, but having nothing to do with expertise, it's protected by general First Amendment right of free speech. But if an expert in the Middle East speaks or writes about it, right, there's added protection for professional speech, but it needs to meet professional standards. And if there's a claim it doesn't, that should be adjudicated by professional peers.
Okay. And so just to kind of continue this analysis, if you are a faculty member whose expertise is not, for example, Palestine, Israel, or the Middle East, or international law, international human rights law, but you are commenting on this issue, which is clearly a matter of public concern,
Yes.
especially in the United States, and you're doing it in your social media content, and then you are attacked for that, or there are individuals or groups who seek to harm your economic, your livelihood, or your job security or your job, then actions that were adverse to your employment would be analyzed under the First Amendment. And so if you are a faculty member, again, that's not their expertise, but they are at a private university, does that mean that they're effectively unprotected?
Yeah, so I was going to mention this public-private distinction in my comments, but you only gave me 25 minutes, so I had to cut something out. But I'm glad you asked. So this is a very important point to make. As lawyers are taught, sometimes they forget, but I don't think the general public is often aware that the First Amendment protects against action by the state. The First Amendment does not apply to private action. So this means that if Congress or the president, for example, takes an action that affects academic freedom, professors at private universities as well as public universities have a First Amendment case because there's state action. The action is coming from the legislature or the executive. Also, if a public university administration or trustees takes action against a professor at a public university, there's a First Amendment case by a professor against the administrators or trustees who are acting for the state at a state university. Say Rutgers, for example, to take a random example. But if it's a dispute between professors and administrators or trustees at a private college, the First Amendment does not apply. Princeton University, for example, to stay in New Jersey. I want to make one further point about this, however, which is that often private universities voluntarily accept for themselves the limitations that the First Amendment requires of public universities. Because private universities often, not always, don't want to appear to afford less protection for academic freedom and free speech than their public counterparts. When I was a student at Stanford Law School, Stanford brought disciplinary charges against a professor who Stanford alleged had incited to riot. And the Stanford administration told the faculty hearing committee, we want you to apply the First Amendment standard from the Brandenburg case that applies to Berkeley across the bay, a public university. Stanford did not want to be perceived as providing less protection than Berkeley, even though it didn't have to as a matter of law. So that's a very important thing to keep in mind. Also, professors at private universities, though not protected by the First Amendment with respect to administration and trustees, are often protected by provisions in faculty handbooks that have contractual force, by collective bargaining agreements. There are other ways to protect academic freedom than the First Amendment. And I think people often lose sight of these other ways.
Thank you. That's really helpful. And again, I would highly recommend that people read Professor Rabban's book because he does go into detail about these issues. We've had a number of questions related to student academic freedom, which you do also discuss in your book. And so could you give us a bit of a summary of student academic freedom? And I'll just follow up, or I'll include, there is a question about the concern with the various changes in policies on campus demonstrations and protests, especially in response or with a clear motivation, I don't think it's hidden, to quash or to minimize or to marginalize those protests, seeking the ceasefire in Gaza, again, alleging that what Israel's military is doing is genocide, supporting Palestinian human rights, and so on and so forth. And so many universities have, I would, my position is I think abuse the time, space, and manner provisions or the doctrine that's been proffered by this court. That's my position. Everyone agrees with it. But how do you give us an analysis of student academic freedom, especially within the last 3 years?
Okay. Basically, bottom line is that courts have not really recognized a student right to academic freedom. A few decisions mention it. There is language in Supreme Court decisions indicating it might recognize a student First Amendment right of academic freedom, but it's really not been established. Many cases, however, recognize student free speech rights in all kinds of contexts, in demonstrating, in student press cases. So there's lots of First Amendment protection for student free speech. There really hasn't been protection for a distinctive right of student academic freedom, in my opinion, and that's why I included a chapter on student academic freedom at the end of my book. There are good arguments for recognizing a student First Amendment right of academic freedom, just as academic freedom was extended from professors to institutions in the 1970s based on the right of institutions to make educational decisions. I think there's a plausible argument that the First Amendment right of academic freedom should extend to what I would call the student interest in learning. That's an educational value that easily comes within the ambit of academic freedom. So I would hope cases would recognize student academic freedom as something distinctive in an educational environment, but cases really haven't done so yet. Should I go on to answer your comment, Sahir, about changing rules midway with respect to demonstrations? So as you indicated, in general First Amendment law, there are what are called permissible time, place, and manner restrictions on speech. So, for example, it doesn't make sense to schedule like 2 demonstrations in a public park at the same time. You need to kind of regulate that. It's legitimate, cases say, to prohibit speaking like from 10 p.m. to 6 a.m. in certain contexts where that would disturb people, disturb people who are trying to sleep, whereas during the day, that kind of speech should be allowed. There are lots of questions, and speech rights can be limited to what are public forums on public property. People do not have a right to speak on any government property anywhere. You can't speak in a public building where work is taking place. You can limit speech to what are called public forums. There are lots of difficult lines, like what's a public forum, what's not a public forum. How much of a university campus at a public university is a public forum or not a public forum? And a particularly difficult issue is there's something called a traditional public forum, like a park, which is always a public forum. There's also something called a state-created public forum. A state does not have to create a public forum, but once it does, designating particular property as open to everybody, the state must apply the same rules to its own created public forum as it must apply to traditional public forums like parks and streets. But the state can shut down the public forums it has itself created that are not traditional public forums. I know this is complicated, but it's important to understand this to answer your question. So with respect to these recent demonstration and changes of rules, the key issue would be, has the state kind of reconsidered its decision to open a public forum? Has the state university, for example, decided that allowing this space on campus to be used for speech, even though it's not a traditional public, it's not like a park space on campus, it's some other space, that was a mistake, we're going to close that down. Under general First Amendment law, the state can do it. The state can shut down a state-created public forum it didn't have to create in the first place. But it can't do it for an impermissible reason. It can't do it because it disagrees with the speech of someone who wants to use that public forum. So this issue would be very fact-specific with respect to each incident. I hope that's at least the start of an answer to your question.
No, I think that's very helpful. You probably won't be surprised that many of the students across the country who are engaged in protests and demonstrations, and then you also have the issue of encampments, which has its own kind of complications in terms of whether that, if you want to comment on that, I think a lot of people would be interested because there was such a massive nationwide elimination or crackdown and forced removal, sometimes through police, of those encampments. And the universities had their own justifications, but assuming that it is more of a traditional protest, there are certainly suspicions by many students, and I think they're reasonable in having those suspicions or skepticism that the motivations, right, for changing the rules and for no longer making what used to be historically the place where students express dissent or collective speech, no longer that place, and suddenly the new place is very far away at the very corner of campus where nobody can hear them or see them, which in some that kind of defeats the purpose of protest in many ways. So if you'd like to comment on the encampments, you're welcome to. I'll add a question from another guest, which I thought was interesting. This is the question. At my institution, Penn State, the graduate school recently updated its, quote, professionalism, end quote, policy to include a clause stating that students must refrain from using academic, research, or clinical platforms to advance personal or political opinions. This revision followed instances when students raised concerns about the genocide in Gaza during scientific seminars. So how should students and faculty navigate academic freedom under such policies? And how can we responsibly engage in urgent humanitarian or ethical issues within academic spaces without risking institutional retaliation?
Right. So briefly on encampments. My impression is that encampments cover like a wide variety of different things, including where they're located, etc. I don't think many encampments follow kind of traditional public forums. The encampment has not been, at most universities, I don't think, a traditional use of university space. And I think in many instances, universities could justify prohibiting encampments that last, say, significant periods of time. But once it allows an encampment for one kind of group with one kind of message, then to say another group can't use it raises these issues of motivation. I think some university presidents have allowed encampments that are contrary to university policies, as long as the people in the encampments are following certain kinds of rules. So that's another way that encampments have been dealt with. So on this second question about professionalism, the issue for me is the subject of speech about the Middle East, maybe that's a good kind of general term to talk about a lot of these sub-issues. Is it related to the subject matter of the course? Okay, if it's a course in like contemporary Middle Eastern studies, right, it's obviously related. And people can express personal views that are also academic views. I mean, one can reach an academic conclusion that also reflects a personal view. And as long as the academic content is justified on academic grounds, it should be protected. And in my view, a student right to academic freedom, but also just a general student right to free speech, should include speech related to the subject matter of a course that meets academic standards, as again determined by expert professors. So even student speech in a class on contemporary Middle East that kind of is wrong under contemporary standards, or is not expressed in kind of academic terms, might not be protected. Now, what if students talk about the Middle East in a course on physics? That's not protected in my view. It's not related to the subject matter of the course. It's perfectly reasonable to limit expression by the professor and the student to what the course is about. But even there, I think there can sometimes be exceptions. And I want to give you one from my own experience. So, showing how old I am, I was a freshman in college when Dr. Martin Luther King was assassinated. And the first class the next morning that I took was freshman chemistry. And at the beginning of class, the professor, very emotionally, talked about how devastated he was by the assassination. I'm sure he only meant, to say some comments at the beginning of class. But it turned out like students had things to say. And the discussion expanded from the assassination itself to race relations on campus. And the professor allowed that discussion to go on for the full hour. That had nothing to do with chemistry. I would also say it was probably the most educational hour I have ever spent during my long career as a student. I say this to indicate this is like the exception that proves the rule. Every once in a while, it may be appropriate, or at least defensible, to spend some class time on subject matter unrelated to the course. But that should be extremely unusual. So I would say, like, this professor should have been protected for what he did, should have been even applauded, perhaps. But if he used the entire rest of the chemistry course to continue discussions of these issues, that would not only be unprotected by academic freedom, it could be cause for discipline, for not doing your job.
Okay, that's really helpful. I mean, all of these are, as you said, very fact specific, and then the question, of course, is access to justice and whether students have the means, and resource-wise and expertise and access to lawyers to litigate if they find that their academic freedom rights are being violated. And with
I mean,
faculty,
free
obviously,
speech,
the
free speech
AUP
rights.
right now is carrying a very heavy lift. So I'll ask you another question by one of my esteemed colleagues at Rutgers Law School, Professor Carlos Gonzalez, who's also a First Amendment expert. And the question is, does your approach to free speech rights and academic freedom in any way resemble longstanding free speech law forum doctrine? In other words, are you in essence arguing that professors should be protected from viewpoint discrimination within the certain limited subject matters, such as areas of academic expertise or academic policy? Is this in essence similar to limited public forum analysis, which prohibits viewpoint discrimination but allows subject matter and quality discrimination? Could parallels to existing forum analysis be one path to getting around Garcetti and the rule that government employee speech that is part of the job is not protected? In other words, can we frame most of the job-related tasks of professors are operating within a limited public forum and therefore different from speech in Garcetti and other public employee speech cases?
I think it is conceivable as a matter of advocacy to make those arguments. I'm not sure how effective they would be, but it's a possibility. But I think it is extremely ill-advised in general to use general First Amendment principles such as viewpoint neutrality and apply them in the academic context. That's why I think there needs to be a differentiation between academic freedom and free speech in general. As people have pointed out, right? So for those of you who are not First Amendment experts, right, a core principle of First Amendment law is that the government cannot discriminate on the basis of the viewpoint of a speaker. But in universities, viewpoint discrimination not only often doesn't apply, viewpoint discrimination is appropriate. For example, if someone takes a view within an academic field that is clearly wrong according to disciplinary standards, that viewpoint isn't protected. A professor of geology can be disciplined for saying that the earth is flat. That's wrong. It's a viewpoint, it's wrong. And some justices, particularly Souter and Stevens, have emphasized the inapplicability of concepts such as viewpoint neutrality and content neutrality to the university context. Some viewpoints of students are incorrect on exams. They're just wrong. A student could say it in public and be protected, but a student doesn't have a First Amendment right to say something academically wrong on an exam. So I do think it's important to differentiate academic freedom from free speech in the university context. And I think it is conceptually, theoretically dangerous to try to kind of, I don't know if smuggle in is the right term, but to apply general First Amendment principles in the academic setting when they really don't apply very well, when it's better to look at the educational issues at stake. And I would, as the question suggested, I would protect a lot of the expression that the questioner refers to, but I would do it under academic freedom, not under viewpoint discrimination, general free speech. And I think in the long run, that will lead to better protection for academic speech.
Thank you. That is, I mean, I think you get to the core of the complexity of a lot of these issues and how much we're still wrestling even with the doctrine. I'll end with one more question that impacts contingent faculty, which is, the non-tenured track lines, which is alarmingly increasing across universities as part of what some scholars call the corporatization of universities. And a very frontal, I think, assault on tenure, like in places like Texas, where you teach, and other states, especially in the South and in the Midwest, that are governed primarily by Republican politicians. And so the question about the non-tenured line is, I appreciated your statement that our peers who are also experts, not administrators, should be deciding issues of academic freedom. These decisions in my university are made by human resources and school deans. Are you aware of any institution that has recognized a right to peer evaluation for non-tenure line faculty on academic freedom issues? And related, I think the broader question is this issue of institutional academic freedom versus faculty academic freedom. And so I think when you're dealing with these HRs and the HR professionals and who often don't know the law, and also deans who may not know the law as well, if they are violating arguably faculty's academic freedom rights, or even their First Amendment rights, again, depending the type of speech and the form of the speech and the content of the speech, can the university then hide behind institutional academic freedom if then there were litigation? Because as you know, there are, and you discuss this and you also talk about it a lot in your book, there are cases where the universities tell the courts and the judges, stay out of our business, right? Part of academic freedom is deference to us. It's kind of like the executive telling the courts, defer to us on all these plenary power issues. So how do we kind of reconcile these two issues?
Yes, so I have in my book a long chapter about conflicting claims of academic freedom between universities as institutions, claims made by administrators, trustees, as opposed to claims made by faculty. Sometimes a judge should find for the university, sometimes for the faculty member. In my view, but this hasn't been the case law yet, and in my view, courts tend to be overly deferential to administrators out of the understandable reluctance to get involved in university affairs. You know, sometimes deference to administrators and trustees is appropriate. There are issues over which they have control. You know, there's a joint statement on university government by the AAUP, the Association of Governing Boards of Colleges and Universities, and I think the American Council on Education, you know, indicating which types of decisions within universities are most within the competence jurisdiction of which parts of a university. And I think that statement, though it doesn't have legal force, gives useful guidance to courts. I think, and I say this in my book, that when it's an issue of whether the speech meets academic standards, the court, in many cases, there has been a peer review determination, and I think courts should defer to it, though still review it. You know, what if the peers have discriminated on the basis of race or sex? You shouldn't allow that to stand. That's an appropriate role for judicial review. But generally, you know, courts should defer to the academic decisions of universities, but those academic decisions with respect to appointment, retention of professors are traditionally made by faculty peers and should be. In my view, if a university has not used peer review when it should, courts should order it before making a decision. As to contingent faculty, they should be covered by academic freedom too, right? Tenure protects academic freedom, but academic freedom is a First Amendment right of professors, whether or not they have tenure, whether or not they are on tenure track or are adjunct or contingent. If you are qualified to teach the course based on your expertise, according to the university, then you are protected by academic freedom. I don't know if that gets into all of these complicated issues, but it's a stab at it.
No, thank you for that. And I think the other issue that is, you get into this intersection of anti-discrimination law and academic freedom and First Amendment rights, which is quite ripe. And some of it is probably going through the courts now, where you have students and faculty will allege discrimination, but the basis of the discrimination, the facts that they point to, are often purely speech, right? Whether it's speech in the classroom or whether it's extramural speech on social media, alleging that they can then, don't have equal access to the education process, or that they feel unsafe, or that they feel they won't be treated fairly, or et cetera, et cetera. And that's where then the human resources professionals tend to have kind of the broadest jurisdiction on these anti-discrimination issues. But many of them, at least we're talking about DEI, when we're talking about LGBTQ issues, Palestine, many of these things are front and center. And it's really putting professors in a really difficult spot because, at least based on my observations, university administrators seem to be less and less concerned with protecting their faculty as they are with pleasing politicians, the President of the United States, their Board of Trustees, and their students, who are often just upset because they disagree with those viewpoints, or they disagree with the professor's speech. So that I think that is ripe for either litigation or certainly some scholarship. So with that, I wanted to give you a few minutes if you wanted to make any closing remarks before we end our presentation. Professor Rabban?
Well, I just want to reiterate my appreciation for the invitation to speak. And I appreciate all the excellent questions and comments afterwards. I've really enjoyed this session, and I hope it's been useful to the participants. Thanks again.
Thank you, Professor Rabban. It is truly an honor, very personal honor for me to host you. And for those who want to watch this again and share this lecture, it will be posted on the Center for Security, Race, and Rights YouTube channel. So just go to YouTube and Google and search Center for Security, Race, and Rights. I strongly recommend that you purchase and read Professor Rabban's book, Academic Freedom: From Professional Norm to First Amendment Right. You can go to the Harvard University Press website and get a 20% discount by putting ACA 20. For those of you who received registered for CLE, the first code is academic, the second code is expertise. And finally, please be sure to subscribe to our Race and Rights podcast. And our next lecture in the Free Speech and Racial Equality lecture series, which you can find at csr.rutgers.edu under lectures. And so with that, thank you so much, Professor Rabban. Thank you, everyone, for joining us. And we'll see you at our next lecture.
Bye.